Hello, everyone. Good afternoon, distinguished judge and participants. I extend a warm greeting to each one of you who have joined here. My name is Vismaya, and I will be your session observer to the much awaited finals of third international mediation competition jointly organized by Newcastle University and Lex Erudites. Thank you for joining us. Now, let me introduce the adjudicating panels of juries we are having. His Honor Philip Kramer. He is the judge in charge of the business and property courts in Newcastle. He is authorized to sit as the judge of the High Court in the both Chancery and Queen's Bench divisions, including the Circuit, Commercial and Technology and Construction Courts and Administrative Court. Welcome, sir. Next, we have...
Hello, I'm glad to be here.
Yes, sir. Next, we have Mr. Inpavijan Veeraraghavan. He is an international arbitrator and mediator. So far, he has represented as counsel in over 400 domestic cases and financial arbitrations, and also in international, about 17 international arbitrations. Welcome, sir. Now, yes, sir is there. Next, we have Honorable Dr. Sharif El-Lakahi, Chief Judge, Cairo Economic Court, Egypt, and mediator of the Global Mediation Panel of the Office of the Ombudsman for UN Funds and Programs at United Nations. Welcome, sir.
It's a pleasure. It's a pleasure, everyone.
We are fortunate to have such a grand panel of juries for the session. The stars of the day, I should say, the team IMC 2325 and IMC 2335. The client and counsel from IMC 2325 will be representing Ray, and client and counsel from IMC 2335 will be representing Sam. A warm welcome to all the participants. I could see a very energetic smile in each one of you. I hope you are cool and ready to. Yeah. Let me read out the rules given to the participant, and participants are requested to follow the rules and regulations. I know every one of you are very thorough with it, but still you know the drill. The total duration of the session is 1 hour, that is 60 minutes, wherein 15 minutes for the mediation and 10 minutes for the judges to give out their remarks. Mediation session also include a maximum of 6 minutes, which will be allotted for the joint mediator for opening statements. Mediators will be allotted via the chat box at the end of the 5th minute. A maximum of 4 minutes each will be allotted for the negotiating team for opening statements. Teams will receive a notification at the end of the 3rd minute. There will be 1 caucus per team, a maximum 5 minutes for each team, which can be requested either by the mediators or by the party. If speaker surpasses the allotted time, the session observer will signal the conclusion. At the 49th minute mark, the session observer will notify all the participants the same. So I request everyone to keep a tab on the chat box, as all the further communication will be through the chat box. That's all the rules and regulations for the finals. I hope I'm clear to everyone. Is there any clarification needed? Perfect, right? So if the judges could give us a thumbs up, we can begin the session. Perfect. So now it's time. The most defeated moment of this year. I welcome the mediator to take over. All the very best, participants.
Thank you. Thank you so much. Before I start, I would like to tell it's a wonderful opportunity before all these judges. Now, let's get right into the session. So, good afternoon, good evening to one and all present here. I am Tina. I will be a co-mediator for the day. And before I start off, I want to show my deepest condolences for the loss that has taken place. And yes, losing a loved one truly must be a challenge. I really hope all the parties to acknowledge that fact. And let's move on further from that. I pass on the mic to my co-mediator to give a brief introduction, followed by the introduction of the parties.
I would welcome all of the parties for this mediation settlement. He had choose the mediation as the mode of settlement, being it voluntary process. I am Mr. Smith, a co-mediator for this mediation process. I would thank the parties for appointing us as a mediator, and I also like to mention that we mediators doesn't have any vested interest involved in this mediation, and we will be remaining neutral throughout the session. Before we begin, I will like a brief introduction from both of the parties, and please let us know that how they like to be addressed. So we can begin with the requesting party. The party representing hospital may proceed with their introduction.
If possible, the timekeeper, could you not include this time within the opening statements? Thank you. Just the
Yes.
introduction. Thank you so much. Carry on.
A warm greeting to everybody present at the table. My name is Mr. Reshant, and I'm the Chief Executive of the Newcastle Health Board. And I come here with full and absolute authority to make decisions on the behalf of Newcastle Health Board.
A very warm greeting to everyone present here. My name is Ms. Himani Kullar, and I'm the counsel on behalf of Mr. Ray. You may address me by my first name or as Ms. Kullar, whatever deems comfortable to you. I hope we have a fruitful session.
Thank you, parties, for their brief introduction. Now I will request the parties representing Sam to give the brief introduction about themselves and also let us know that how they like to be addressed.
Good evening, everybody. I am Sam Barnes, here on behalf of myself and my wife, deceased wife, Ashley. And this is my counsel.
Yes, my name is Sarah. You can address me as Sarah throughout the session, or the counsel for Sam, whatever you're comfortable.
Thank you,
Thank you.
parties, for your brief introduction. Yes, now my co-mediator will explain you some basic features of the mediation before we proceed on understanding a detailed procedure. It's a pass over to you.
Thank you, co-mediator. Thank you, Smith. I really hope today will be a wonderful session. I do understand that there's a lot of emotions in place, and throughout the process, I feel all the parties should respect and acknowledge each other's emotions. So let me get on to explaining what mediation is, so that each and every party know their roles and how they should act throughout the session. Mediation is a party which is a process which is facilitated by a neutral third party to assist the whole procedure and to attain a common resolution. And today, I really feel the parties should be able to communicate, and we as mediators will ensure that the parties are at a good, safe environment, and we will ensure that all the issues can be placed before us. So before I start off by telling what we as mediators do here, I would like to say, yes, emotions are strong, but they either can be in our positive and they either can be in favor of justice and may not sometimes. And today we will be acknowledging that fact and ensuring that justice and emotions both are discussed. So, us as mediators are three things. We are non-judgmental, non-biased, and neutral third parties. We are not invested in the matter, and we will ensure that you find the solution to your own problems. Since today both the parties have agreed to be here voluntarily, I really hope both the parties are willing to communicate at utmost and more effectively and efficiently. And being in the mediation does not allow that you have admitted for any wrongdoing or guilt. It's to ensure that both the parties communicate at large. So before I give on the mic to my co-mediator, who will be explaining the process in detail, I would like to ask three questions. Are the parties here voluntarily? A thumbs up would do. And are the parties here in good faith and ensuring that you might be in a better position after the session? And do the parties have authority to take decisions and even make an agreement to settle today? Thank you. Thank you so much. And I pass it on to my co-mediator.
Thank you, Tina. So, before we begin to the procedure of the mediation, I just want a few clarifications. That is it the first time that parties are appearing for the mediation process, or do they have some experience in past of mediation process? Okay.
Yes, it is
So,
the
as a
first time.
mediator, okay, thank you, parties. So, as a mediator, it is our responsibility to explain the procedure of mediation, which we will be following for today's session. And as mediation is a voluntary process, you are not forced to agree to the settlement which you are not comfortable with. So, the procedure for the mediation will go as follows. First, the parties should be begin with their opening statement. Opening statement would be the brief introduction or brief of your contention or the issues. Based on your opening statement, the mediators will formulate an agenda. Agenda will be nothing but how the discussion will be flowing throughout the session. So if the parties may feel something to add or to remove out of the agenda, the party may do so. Also, in case we find stuck ourselves in bit of pickle, then thankfully we have a provision of private caucus where we can banter and brainstorm a solution to get out of the tight spot. So any information revealed during the private caucus session will remain very confidential, and any documents or notes prepared during the private caucus session will be destroyed or retained according to the will of the parties. If information the parties may feel is to be disclosed to the other party, they will do so. Also, this mediation process is a completely confidential process, so any information said here or any input given by any party shall not be disclosed to the outworld at all. Also, as a mediator, it is my responsibility that I have to interrupt you sometimes in case if there is some clarification needed, so that we could better understand the process in case there is some summarization needed. So I have to interrupt you sometimes. And as mediator, I believe I have reiterated my title thrice now. As a mediator, I would also request the parties to kindly refrain from using some impolite expression. I would prefer some punchlines rather than verbal punches in case there is a bit moment of intense, so that we could make most out of the allotted 50 minutes time. And again, as mediator, I would be very conscious of time. So kindly have a note on it. So before we begin with the mediation process, I just want a few clarification more that are the parties agree to allow us to prepare a notes for mediation session, and these notes will be destroyed or retained with the consent of the parties. The parties allow us to prepare the notes for the mediation session. Thank you, parties. Now I will request the requesting party to begin with their opening statement. So I will request the hospital parties representing hospital to begin with their opening statement.
A warm greeting to everyone present at the table. My name, as mentioned, is Mr. Reshan, and I'm the Chief Executive of the Newcastle Health Board. I'm thankful to the mediators for explaining the process of mediation so beautifully, and we're grateful that Mr. Sam accepted our invitation for this mediation session. At the very outset, I extend my heartfelt sympathies to you, Mr. Sam, and the Burness family for the immeasurable loss of Miss Ashley Barnes. I wish to convey our sincerest condolences to you, your children, and everyone impacted by Ashley's ultimate departure and such an untimely passing away. It is an undeniable tragedy that has deeply affected not only the Barnes family, but also our hospital and the community we serve. Mr. Sam, I want to express a profound regret and sorrow for these circumstances. There are no words that can adequately ease the pain of such a loss, and we recognize its magnitude. However, in this session, I am here to present the hospital's perspective while acknowledging the gravity of the situation. You see, our hospital is committed to delivering exceptional care to every individual who seeks our help. Nevertheless, our hospital, like many healthcare institutions, operates within a complex environment which faces challenges and constraints. The circumstances on the night that Ashley sought medical assistance from us was inundated with such emergencies, which regrettably resulted in a delay which had tragic repercussions. But we stand committed to ensuring that such incidents are minimized, if not eradicated entirely from our system. Nevertheless, we cannot overlook the lapses that contributed to this. Uh, this is a matter of profound regret, but our commitment goes here beyond a mere resolution and extends to an earnest endeavor to introspect, rectify, the systemic shortcomings, and fortify our commitment to exceptional patient care. Here, our interests are not only aligned with resolving this tragic incident, but also ensuring that the hospital's ability to continue providing exemplary care to the community. Now, in this regard, we find it important to address the events that took place on the night of 12th July. The events that day must be viewed in context of what was happening right outside our hospital that night. It was a day where a violent riot had led to an extraordinary increase in the number of patients we received, and we made our best efforts to ensure that the first available doctor to reach that night reaches to you on time. Unfortunately, the cases of appendix burst are evasive, and a triage nurse could not find an immediate or urgent need to proceed upon preliminary examination. In closing, despite the fact that we tried our best to save Miss Ashley, we understand the concerns that you have brought with us today. And in closing, I would like to say that mediation represents more than a quest for a resolution. It signifies a commitment to honor Ashley's memory, to rectify our deficiencies, and to forge a path that upholds the highest standards of care while ensuring that tragedies like this become a rarity, if not absolute at all. And I would like to end by saying that both law and education are noble professions. Miss Ashley was a teacher, and our industry professionals are doctors. There is an intricate relationship between the two, and I find that the process of mediation is essentially the bridge between the two noble professions. I would now request my counsel, Ms. Himani, to carry forward this discussion to explain the legal intricacies of this matter.
Thank you, Mr. Ray. First of all, I would like to thank Ms. Sam for accepting our invite for this session, and to Tina and Smith for agreeing to mediate this session. I would like to start by expressing my condolences to Ms. Sam for the loss that you are facing currently, and I hope that you gain the strength to tide over this hardship. Before we move forward, I would like to emphasize the fact that I'm here in a merely advisory capacity to safeguard Mr. Ray's interest, and Mr. Ray has the absolute and unqualified authority to make decisions on behalf of the Newcastle Eastern Infirmary. Also, I will be taking notes during the session, but that is just for our reference. Sarah, or the counsel on the opposite end of the table, I'm sure you would agree that in law we speak of a lot of things in black and white. But the way I see mediation is that it helps us transcend beyond that binary of black and white and actually delve into the heart of the matter where both sides emerge victorious. While I understand that you are going through a tough time, but I hope that when this mediation session is over, you do see that you have won something here. When my client approached me with this issue, I advised the mediation route because I strongly believe that what can be resolved through talks and discussions need not take the form of protracted litigation. And that is why we are here today, to put forth our interests and hear your concerns. Now, Mr. Ray has very eloquently put forth what we plan to discuss here, but I will briefly, for everyone's benefit, sum up our interests here today. First, we wish to discuss the amount of compensation for losses incurred and other possible remedies in exchange for withdrawal of the court case put forth by Ms. Sam. As stated by my client, and as is the position of the hospital, there was no negligence on our part since the hospital followed the correct procedure and everything was followed as per the code of conduct. However, as a gesture of goodwill, we are willing to provide you compensation for the huge loss that your family has gone through and help you tide over this period of hardship. Second, to discuss the confidentiality of the event and the entire proceedings. I think it goes without saying that since there was no fault of the hospital in the present scenario, we won't like this to get out in the media and have it blow over. And hence, we would like this session to just be between the two of us. But at the end, I would just like to say that I hope at the end of this session, you are in a better position than right now, because this is the aim of mediation and this is what we hope to achieve today. To sum up our trust in just 2 lines, it would be A, discussing the possibility of a settlement in exchange for withdrawal of the court case, and B, confidentiality of the whole agreement. I hope we have a fruitful discussion. Looking forward to it. Thank you.
Thank you,
Thank you.
parties, yeah. So now
Thank
I
you so
request the
much.
parties representing Ray to kindly begin with their opening statement. Sam, to kindly begin with your opening statement.
Yes. Thank you, mediators, for clearing out everything. And I would really like to thank the opposing party to be present here as well for the mediation process. Although I would really like to convey that I am not in a very great mental space as of now. So please do excuse me if I get a little emotional. Uh, so a night that was supposed to be of medical assistance very unfortunately turned into a very irreversible tragedy for me and my family. My husband Ashley's death has been a great loss to my family and is an invaluable thread of loss that has been caused to my family. Ash and I were both teachers, and as a head teacher of an institution, I do understand the challenges that institution has to face when it comes to great responsibility to fellow be it students or patients in your case with regard to hospital. So that is something that I do take into consideration. But at the same time, when we talk about the issue at hand, I am very although I feel humble that I'm at this mediation, there are a lot of issues that really break my heart when it comes to my husband's demise. The fact that my husband was in the hospital, was admitted at 12 in midnight, and was not adhered to till about 8:30, and 9:15 was when it was announced that he died. Given that I feel somewhere there has been some amount of negligence on the part of the hospital, but it is something that we are here to discuss about. So I think my counsel would elaborate on my stance here. Thank you.
Yes. Good afternoon to everyone present here. Ray, counsel, both the mediators, thank you for making my client comfort at this very emotional times. It's very commendable for both the mediators. And I would like to clear out that my role here is to guide my client today, and it is very open to my client to either reject or accept all the options generated in this session. I would also like to point out that although my client could have gone for litigation, considering the emotional turmoil, I strongly suggested my client to go for mediation. And I hope the opposing party is considerate of the situation, the emotional situation that is there right now. With that, I would urge my client as well as the opposing party, opposing team to please stay focused on the fact that we have to come up with as creative solutions as possible to reach a middle ground, which will be difficult in this case, but we shall try our best, and to not deviate from the main agenda or main discussion of the mediation. I would like to lay out the agendas for today's mediation. So we have three main agendas. The foremost and very prior one for my client is compensation. Compensation for losing out on her life partner, her emotional turmoil, and also other financial situations. The second one is for the scholarship of my client's children for the higher education, as my client has two children and would like to make sure that they could get good education. And the last and the third one is mediation committee fund. I think my client would personally like to ponder upon the third agenda, as this is very personal to my client's heart and was specially requested to me. So I think keeping all these agendas in mind, we would we look forward to a fruitful session, and I hope we come to a conclusion. Thank you.
Well, thank you. I thank both the parties for giving a brief opening statements. So before we get the agenda, I would like to summarize everything which was told till now for the parties to communicate more effectively and easily. So if we look at the perspective of the hospital, Newcastle Hospital, what Rishan say is that they also feel deeply sorry for the loss which place, and the situation has am I am I audible?
You were not audible in between.
Am I
Could you
audible?
please repeat what you said?
Okay. I would like to sum up, or I would like to summarize all the opening statements so that both the clients and councils can communicate more effectively. So as per Ray Shand, who is representing Newcastle Hospital, he would like to say that the situation which was due to unforeseen situation because of the riots taking place and everything. Uh, Yeah, because of riots taking place and everything which took place that day was as per the code of conduct. And yes, what Sam's side would like to say is that they are not in an emotional state of mind. They might get emotional today, and they are truly stated by their laws and would like to look at their future positive, the future of their family. So, go parties, we can start discussing. Any would like to clarify, please to let us know throughout any part of the session.
Since
Yes, I
Madam,
pass it on to my co-mediator.
yes, I would
Thank
just like
you.
to interject here if possible. Since Madam Mediator was not very clear, I would request the other mediator to kindly clarify what she has just stated.
Yes, I will state what are the formal agendas which we have formulated after listening the opening statement of both the parties. So amount of losses incurred, the status of legal case, and the alternate remedy if possible. And the second agenda would be to discuss the confidentiality of the events. So this is the primary concerns of both of the parties, which we could infer from the opening statements. Is this fine with both the parties, or there is something else which the parties need to add to this agenda?
If I can just add on to what everything that has been laid out. With regard to everything that has happened, I would also like to state that I have in the past come across a lot of news items and the media coverage that the hospital has gotten with regard to its history with cases that it has had. And it is unfortunate that my husband Ashley was also happened to be one of them. So in that light, if the hospital, the representatives of the hospital can also give us an overview of the medical protocol reviews and the emergency overloads that they have faced when it comes to that night specifically, we would really like to be enlightened on that as well.
Okay. Thank you, parties, for your inputs. We acknowledge your input, and the right agenda would be to discuss the amount of losses incurred, the status of legal case, and any alternative remedy if possible. The second agenda would be focusing on to give the detailed procedure of the protocol if it was followed or not, and the confidentiality of the event from the perspective of other parties. I believe this addresses the interest of both of the parties.
If I can add on to what my co-mediator said, hope I'm audible. Are there any network issues? Is it all fine now?
Yes.
Okay, thank you. So if I would like to add on to my, since we are also, I always believe in the process of past, present, and future. So yes, we do need to look at the past, even look into the future. If we get into the agenda of the stipulations and how both the parties will be going on from now, if that be added, it would be very beneficial. If the parties are fine with it.
Could you please repeat what the last line you said?
Future reasons as to how the party will be resolving, especially with respect to the future of SAM, future of hospital. Am I audible now?
हमारा भी चला जाए.
Are you asking
Am
about
I
the
audible?
private caucus?
Asking the private caucus. I meant the future of
If I can just add, I think we're having an internet issue. If we can just have a minute to.
Can we hold on the meeting for like 2 minutes to resolve the issue for the interest of both the parties?
Sure, I believe that works. We can allow the mediator some time to join back.
Yes. I will request the mediators if they
will
want
now.
and I would request the administrators if they want to stop the time timer till now so that my co-mediator could join in.
Is everything fine now? Am I audible? Are there still network issues that are being faced?
Yes, you are audible.
Thank you. Please let me know in the chat box when I do not become audible. Yeah, even though I would love to be present physically and we are on a virtual platform, there is high possibility of technical glitches like this. So yeah, what I was trying to say is if we can add in the agenda with respect to the future of SAM and how the future of the hospital will be working as to the policies and the future of SAM as to related to the family. If the future of both the parties can be added in the agenda, maybe that'll be beneficial if the parties are fine with it.
I do believe that when we're discussing past events, it's very important for us to discuss our respective futures as well. So I believe that is something which is in the interest of both parties present here.
Yes, okay. Thank you so much. Since the agenda has already been set, if Smith can reiterate it, we can start with discussions if the parties are fine with it.
Thank you, Tina, for this wonderful explanation of the agendas. Now I request the parties to, requesting party first, to kindly briefly introduce your contentions or what are the alternatives which the other party could accept, which could meet the interest of both of the parties. So I will request the parties representing Ray to kindly begin with their contentions.
If I may interject here, before putting forth offers for the resolution of this dispute, we would be really grateful if we could ask certain questions to the other party so that we get to know where they're coming from. At this juncture, I'm very curious to understand what exactly happened on the night of 12th July from your perspective, Ms. Sam. Could you please describe to us exactly what had happened that night?
So if I had to talk about what exactly happened on that night, it was a very busy night for me personally. I had an emergency with my students. I was doing some schoolwork along with my husband, and there was a medical situation where he was facing very minor stomach aches. For which we had to take him to the hospital. He was feeling a little nauseous, and it was not something that at that point we thought could be extremely serious. Which is why I had made the decision to stand still and make an informed decision to help him out. And at around midnight on that day, he was admitted to the hospital and he was waiting for the appointment. And it was brought to my notice that about until 8:30 no one was attending my husband, and there was no, even though he started complaining about a lot of stomach aches that he was having and it was getting serious, and it had to reach a point where he had a burst. So that is something that was extremely uh, sad to witness. And followed by which at around 9:15 was when the doctor had actually announced his death. And it was very disheartening because only at the time when it had to be announced that he actually, there was nothing that could be done, is when we actually got medical attention from people at such an alarm situation. And prior to that, we really didn't have much information or attention that was given to us from the hospital.
Thank you for answering that question, Sam. We do understand your pain in this regard. However, to proceed further, I am naturally curious about certain other things in this regard as well. How was Miss Ashley's health generally? Were symptoms like these common in her case, or were these happening specifically on that particular night?
From what I can say is that I think Ashley was in the brink of his health, and there was nothing that actually, at least as commoners, there was nothing that we could assess, not coming from a medical background. And he was so healthy that I think he almost had 15 more years that he could have actually worked, even career wise. And that was something that was really sad to talk about as well when it came to our notice. So.
I see, Miss Sam. It is a loss indeed. Uh, but to
If I may interrupt,
sure.
if I may interrupt, I'm really sorry to interrupt. I think my client is not able to speak up that much for herself today, considering the situation. But I would, like the responsible counsel for my client, like to point out that the medical negligence by your hospital cannot be ignored. The tired nurse who was supposed to do all the basic evaluations and assessment of my client's husband did not do it properly is why it happened in the first place. Only if the urgency could have been detected at the moment when her husband was admitted, this could have been avoided, and it is a breach of duty by the part of your nurse. So I think even though these situations are there, this should have been taken into consideration.
Thank you, parties. I respect that. I acknowledge your inputs, and I believe that this matter importance to you a lot, and such tragic event is very important to you. We give a due acknowledgement to it, but we as a mediator also believe that it's very. I will congratulate you that considering the situation, you have chosen the mediation, and which is a resort for a peaceful settlement. So I would request the parties that what is your thought process behind, or is there any offer, or either is there any presentation which the other party could expect?
Thank you, Mr. Mediator, for asking that question. First of all, to state it in very blank terms, uh, it is while the incident is extremely unfortunate, and I hold personal sympathies for a cause for this cause. Uh, to the best of our hospital's knowledge and to the best of my capability, I can I can emphasize on the fact that our hospital made its best efforts to save Mr. Ashley's life. Not only was this event happening under extraordinary circumstances on the day of a riot, and on the day of an extensive football match which brought in a lot of patients for us. We tried to send a doctor as soon as possible. And while we understand the fact that appendix burst cases are extremely evasive, it is very hard to detect such cases. And as you mentioned yourself, the initial symptoms were primarily minor. For something like nausea, emergency situations are not particularly created. This was also attested by our triage nurse, who also believed upon preliminary examination that there was there was essentially no need for an emergency, but that often happens in appendix first cases. Now, I would like my counsel to essentially explain where these statements come from.
Thank you, Mr. Ray. While I do appreciate the back and forth, and I do understand that Ms. Sam might not be in the best position to have such a negotiation, and yet she agreed to it, I'm really appreciative, and I appreciate her courage. Um, to reiterate what my client has stated here, the hospital tried its best to save Mr. Ashley's life. We provided our best effort, and yet the unfortunate loss happened. However, the hospital followed all the protocols, in the sense that we provided Mr. Ashley with a triage nurse who, as stated by Mr. Ray upon preliminary examination, also stated that there was nothing to worry about, and we made Mr. Ashley available with the first available doctor at the immediate instance. And as also explained by my client, it was a particularly busy night. We understand that 8 hours is a long time. However, we also would like to re-emphasize that it was an extraordinary circumstances, because there was a football match on the nearby ground, and where the losing team had created a riot, coupled with the fact that there was a concert nearby as well, where the stage collapsed, which resulted in a huge number of patients received by the hospital, and those were very heavy injuries. And when we compare it to some minor symptoms such as nausea and stomach ache, we had to prioritize, and I hope you understand that. However, we are deeply regretful for the loss that was caused to you. In order to compensate you for such loss as a gesture of goodwill, I believe my client here has a number for you. Would you like to share that, Mr. Ray?
Indeed. Now, while I also agree with the fact that our hospital, despite not per se making a case of medical negligence at all, could have been more mindful of the fact that that a lesser number of waiting time should have been provided in your case. We are also
Yes.
here in the spirit of mediation to create, to essentially offer creative solutions to you in this regard. Now, as inferred by your opening statements, you're
If
essentially
I may
you're
just interrupt.
yes,
I'm so
sure, go ahead.
sorry if I may just interrupt. Um, Although I do understand that the hospital is being considerate and providing us with all the aid that we need, we are talking about the issues that happened the night with regard to the emergency that you're talking about, and the triage decision with regard to the nurse and medical protocol reviews. I don't think that we have still been provided with any substantial proof as to how much of care and responsibility and improvement measures have been taken by a hospital. And in light of that, I think there are a few intricate details that we would like to discuss with the mediators. So we would request if we can move into a private caucus.
Am I audible? Yes. Thank you.
Yes.
Yes.
Yes, I was facing some network issues. I wanted to pitch in. It's like Sam has already stated, I do feel that there's a lot of tension in the air, and I feel a private caucus for both the parties would be really beneficial at this point of time, just to lay the emotions and proposals in private so that we can revamp. I have a little bit of homework for the party who is outside the caucus. I would like for them to look into the proposals once again, look into their numbers, and if they want to come up with any other such alternative proposals, please do let us know. So, who would be willing to go for the private caucus first?
If I can go for the caucus first, if I can request to go
Yes.
for one.
Yes,
Okay,
thank
thank
you.
you.
Miss, yes, is there some clarification,
We request the
Council?
administrator to kindly proceed with the private caucus session.
I'm sorry if I may
Yeah.
interject here for just a second.
Yes.
I believe my client was in the midst of offering a number to you, and if the party could hear that before moving into the caucus, so you have some time to think it over. If you could
Hmm.
just make the offer before you move into the caucus, I believe that would be in both of our interests. So you have time to mull it over.
Hmm.
Yes, if the parties are willing to do that,
Although it is not an agenda that I would want to delve into at the onset of our discussion, I think I would still consider hearing the offer.
Uh, Essentially, the hospital, in light of your circumstances, is willing to consider offering you 50,000 pounds as compensation for the pains that you have received, and we are also willing to consider the other damages in the forms of scholarship that you mentioned for your children. Uh, After the caucus session, we would like to hear your views upon this.
Thank you, parties. Now I will request the administrators to kindly proceed with private caucus session.
Wait a moment.
hope I'm audible. Thank you so much. So before we start the private caucus, I would like to reiterate the fact that even though mediation is confidential, this caucus right here is an extra added layer of confidentiality. So if there's something the parties would like to tell us in private, thinking that it would come better if we say it in the joint session, that would be highly appreciated. If the parties have anything to say, please do, and if we have any clarifications, we'll interrupt in between. Hope you don't mind.
Thank you.
Thank
Am I
you.
audible?
Yes.
Yes.
Yes. Parties, welcome to this private caucus session, and believe it's very good opportunity or a chance to enter a good solution for it. We just have a few questions. We will give a detail. We give us just a list of 3 to 4 questions, and after that, you can kindly elucidate your interest so that we could reach to the settlement, which will match the interest of both of the parties. So I expect some few basic questions. That can you identify uh, what the idea behind this session should be to have a mutual gain, right, rather than a zero sum game. So what is the thought process behind your current stance, and what is the lowest which you are willing to go? So these would be my primary questions. And also kindly elucidate your interest very briefly, as it is a 5-minute caucus session, so we want to make most out of it. Thank you, parties. You can go ahead.
Thank you, mediators, for making me so comfortable in this conference. I think I'm extremely deeply saddened by the events. I'm just happy that I'm in a safe space here. Firstly, there are a few legal intricacies that my counsel would address with regard to the negligence and also the amounts. But if I had to state a few things with regard to how my thought process is, so my husband's death was something that was extremely avoidable, and the treatment that was provided to him at that point was totally not acceptable. This is something that I have gained from everything that I have done, my personal investigation as well with regard to my husband's death, talking to the nurses and everything, and the doctors and my friends. So what I feel is that somebody at least must take responsibility and at least minimum apology. That's something that we can talk about later, and ensure that someone doesn't face this in the future as well, because it is something that the lives are dependent on it. So although with regard to thought process, I think there are a lot of things that we could ask for with regard to more than compensation, be it termination of employment of the nurse who was negligent that night, or public apology from the hospital, which would also hamper their reputation. And these are, but we come with a thought process of not revenge, but plain justice. And this is something that we want to lay it out there, because these are the things that we could propose, but we are not, and only talking about compensation with them.
Yes, I would like to add on a few points as to what my client has already mentioned. The first point that the party, responding party had given was that they had adhered to all the protocols, but according to national regulations, the time to attend the patient was 4 hours, which was not followed by the hospital. So that this was one more thing that we would like you to would like you to focus on and inform them. The second thing was as to the compensation amount, that the court is way too less, considering that, as my client has already mentioned, that her husband was in a good health and could have worked for 15 years more. His annual salary was $50,000 or 50,000 pounds. And irrespective of that, my client's children have lost their father. My client is a woman. In this world where it's a male dominating world, she has to look after the children by herself. The salary of her uh, children and the scholarship amount was also one of the concerns, that if they could provide scholarship for the higher education, and also the loss of companionship more than anything else. So all of these things included, my client, and my client, after discussing it with me, has brought the compensation to $700,000, that £700,000 that we could negotiate on. So these are a few things, but the
Thank
main
you.
thing being,
Just a minute. Hope I'm, yeah, just a minute. So I have this one clarification. So why is it that in such a situation you've chosen mediation? I feel that, is there something that you want to achieve from the whole process apart from choosing a litigation? That's something, is there something you would want to tell us in that regard?
Yes, I think my counsel is in a better position to be talking about my legal position when it comes to this matter.
Uh, there are mainly two reasons why my client has gone for mediation. The first one being, in this situation, litigation becomes a very hectic process altogether to go to litigation. And the second one was also compensation amount. She's already lost her husband, but compensation would also need financial stability. And it was best advised by me that more compensation could be get gotten by mediation, considering children's education. That is also further lined up, two children on that. So that's why my client had gone for mediation.
Thank you, parties, that you had very briefly and very well explained your interest, and that we can notice that you were very speculative of litigation, and you then so that why you have chosen the mediation. So we appreciate the fact that both of the parties had agreed to the mediation. So according to the statement, we can conclude of 4 points. So please let us know that which points you want to disclose to the other parties. Firstly, you will request a termination of employee, which was present at the moment. Then you want a public apology. Thirdly, you want the scholarship offer of there for the higher
If I
studies, and
can clarify on
fourth.
that. If I
Yes,
can just clarify,
yes,
explain my thought
yes.
process. Termination of employment of the nurse is not something that we are demanding. It was only something that we could have proposed, but respecting the process of mediation and not a revengeful attitude, and only wanting justice. We don't want anything of that sort. It is something that we could have done, is all that we want you to convey to the hospital.
So essentially we can come down to the 3 points which you want the other party should be aware of. Firstly, the public apology you are requesting. Secondly, you are amounting the demand of 700,000 pounds. And thirdly, you want the scholarship for the higher education of the children. So these were the interests. Before we proceed further, I just have a
If
few
I may
questions that
interfere, if
Yes,
if I
please
may
go ahead.
interfere, we also want you to inform that according to national regulations, it was 4 hours of time that they should have attended my client's husband in. So 4 hours of time should have been the time they should have followed.
Thank you, parties, for your input. I agree that you had suffered such a big loss, but the parties has also stated that there was some tragedy happened adjacent to the hospital, and due to that, there was a rush. And I believe that both the parties are appreciative that they are present at the mediation. So to sharing this information, kindly elucidate that how will that match your interest?
It is
Yeah.
sorry.
No, carry on, carry on. Yes. So, what my mediator Smith would like to say is, since this is a mediation, maybe bringing law would not be the right thing. However, would you like us to say that maybe the proper code of conduct was not followed, and 4 hours was the code of conduct, and was your intent? If that's the case, we can put forward in a very friendly manner so that the other party also does not get offended in the process. And is there anything you would like to say?
Yes, with regard to what my counsel has clarified with regard to following protocol, with regard to the timeline, I think is something that would be reflective of how they have approached my husband when they were supposed to attend to him. And I think when they are quoting such an amount to do away with the compensation, I think it would also help them to reflect on these points that they might have missed when it comes to. Yes.
We truly do understand. Due to a paucity of time, since Smith already stated what you were willing to put in the joint session, let's put this in the joint session, and we can continue for the next caucus. Thank you. Miss Administrator, can we proceed to the Reshan's caucus if it's possible?
Yes, we can.
Thank you.
We just want to clarify, can we leave the meeting right now?
Should we leave the meeting?
We will put you
Wait,
in
one
breakout room.
minute. Before leaving the meeting, I reiterate to the parties that please do get, if you would want to have a conversation in private, look into the financial details and anything else you would like to bring in after having the private caucus. I really hope you could do that for a better communication. Thank you. Yes, ma'am, you can proceed to the next caucus. You are unmuted.
We are doing it. It will take a
Thank
moment.
you.
First of all, thank you, Mr. Mediator and Ms. Mediator, for allowing us an opportunity to have this private discussion. We understand where Mr. Sam is coming from. We understand that Mr. Ashley's death has caused a lot of damages to them, but we are right now unclear as to what exactly they have stated on the agenda, because in our discussion so far, they haven't really put forth any offer or any form of numerical compensation that they may need from us. So could that be clarified to us?
Yes,
Yes,
parties.
yes. Before I start, I just wanted to tell the confidentiality clause so that the parties are well aware about what is happening. So in this caucus, we will ensure that everything you say is within the walls unless you consent to be put in the joint session. So in regards to that, yes, in their private caucus, we have discussed certain things, and I feel it will be more beneficial to the parties to discuss the numbers in the joint session rather than the caucus. So if you would like to tell us anything uh, which we could assist in, and if you could clarify certain problems, certain questions and doubts I had, that would be truly beneficial. If you would like to talk about anything, you can, and I will carry on.
Yes.
Yes.
Mr. Ray, do you want to go ahead?
I believe my counsel, Ms. Himani, is in a better position to answer this question.
Thank you, Mr. Ray. So I would just like to clarify on behalf of my client here that we did offer them a settlement of 50,000 pounds, and yes, we would like to hear their opinion on that in the joint session. Meanwhile, in the caucus, we would like to, my client would like to re-emphasize on the fact that he is on a lot of pressure from the health board, right? The hospital has had previous instances of bad media publicity, and so we are being closely watched. And it's just been over a year when he has taken his role at the hospital, and above anything else, he wants to save the hospital's reputation and his job subsequently. So, in the spirit of that, we did offer them a settlement. However, if there is any apprehension with regard to the amount, we are willing to adjust and even increase the amount of the settlement. But that is on the basis of what the parties say. Further, we do have some innovative solutions for them. I believe Mr. Ray will mention those solutions, and then I can elaborate upon them further.
Yes. Please do continue.
Thank you, Ms. Himani. I do believe that the immediate interest in our regard here is for the other party to withdraw the case that they have initiated against us. In return of that, and after considering what amount of compensation they require from us, since they've not put an offer so far, we would be willing to negotiate the number of the compensation that we may provide. With that said, we are here with a lot of creative offers to address their second and third agendas. Now, I hear them mentioning something about mediation fund. Is that something which can the mediators clarify what that was before we proceed to the creative offers?
Yes, the parties has mentioned that they want a specific route or specific clarification according to the procedure, and there is some information which I will also like to put in place before we proceed. There are some information before you also proceed with the offers. They had demanded public apology, and they have allowed us to reveal this information, the public apology from the hospital, as well as they has demanded that the procedure which was followed, the code of conduct which was followed during that period of the time, or the procedure which was followed, they're very speculative of that, and they have a strict stance on that position. So this is the interest of the parties which are
If I
imperative to
could,
be discussed. Yes. Yes,
if I could
co-mediator
add
Tina, please
to
go ahead.
Smith, in the interest of both the parties and only in the capacity of the mediator and not to sway away you in any sort, is that I've seen some resistance, and is there something you would like to do with respect to the future of the hospital, especially with respect to the pressure that is being put on Mr. Ray as to the media reports and how that has to be, taken care of? So, would the hospital like to take any initiative in that order for the welfare of the hospital and even the welfare of the people in itself? Is that something you would consider?
Yes, that is something we're willing to consider at the moment. While there was no medical negligence on our part, and we are confident about that, we have some creative solutions, such as offering a crowdfunding for Mr. Ashley. We are thinking of creating an Ashley Memorial Fund or even a crowdfunded scholarship program in that regard. There's also a proposal of creating a free library in Mr. Sam and Miss Ashley's school, where her memory will be preserved and the acknowledgement of events like these will be registered by us at a public level, which will help us improve our image and also commemorate Mr. Ashley.
I think just to
Thank you. Would you be willing to use this? Yeah, to carry on.
Yeah, I'm very sorry to interject. So just to re-emphasize and reiterate what my client here has stated, in exchange for them withdrawing the court case, we are willing to provide them a settlement offer, the number for which we can agree upon in the joint session. Further, we would be willing to start an Ashley Memorial Fund in Mr. Ashley's name, and which would help in funding the education of their two very young children, which is one of the concerns that they mentioned in the beginning. So we are totally emphasized with that. We understand how expensive education is, and therefore we're willing to start this memorial fund wherein it would be crowdfunded, but the hospital will put in a token amount in the beginning, so to the tune of 5,000 or 10,000, and then the fund will take place on its own. Second is the free library that we would install in the school that Mr. Ashley taught, just to preserve his memory and all the good that he has contributed to the education sector. So, but I would request the mediators to not mention these offers as of now. I would like my client to mention these to the opposite party, and then I will elaborate upon further. The only thing that we would like you to convey to them is that we are willing to negotiate on a settlement number in exchange for the court case. So you can mention this part, but all the other part, my client would like to disclose it to them themselves so that he can break the news and see, perhaps, hopefully, the joy on their face when they hear our creative solutions.
The parties. With this,
Yes,
I
yes.
believe
Thank
we
you so
got the
much.
end of a private session. So I request the administrator to kindly reconnect the other participants.
If everyone is there's a lot of time. If I judges to just to clarify what all we discussed, that would be highly appreciated.
I'm sorry,
I
but
believe
could you
that
repeat it? Your internet
yes.
was.
Yes.
I believe she has some internet connection instability at her end. So I can briefly state that what the proper private caucus has brought in front of us. The party representing the SAM has proposed an offer where they want a public apology from the hospital, and they had offered the £700,000 as a settlement, and also they had requested for the scholarship of their children for the higher studies. So these are the three primary offers which they had presented to, and the party representing the hospital had presented the offer where they are where they want the legal case to be withdrawn, and in return of that, they would decide the numbers which now has been being put up to the parties. So I request the parties representing hospital to kindly go through the numbers which the party has represented, and the number which they have represented is £700 as the medical as the compensation.
Thank you, Mr. Mediator, for explaining both the sides. Now, before we jump on to the numbers, I also need to categorically state that our hospital is open to an independent investigation, which may be headed by any party decided by Ms. Sam or any other independent investigation agency as well, just to come to the conclusion that we on our behalf have not undertaken any form of medical negligence. With that said, coming to the point of a public apology, because we believe that due to unfortunate circumstances that happened that night, the riots and the stadium collapse, the waiting time was essentially a bit more than what it is usually. Uh, but in that regard, we are open to the possibility of making a public acknowledgement of the mediation outcome at the end of this mediation session. However, that would be for improving both like the accountability that we hold towards the people that we serve, but also contingent on the fact that this case is solved through mediation and not through litigation. Is that something that the other party is willing to consider? I would also like to hear my counsel's views on this.
Thank you, Mr. Ray. I would just like to clarify all the offers that my client has put forth. Firstly, we are offering an independent investigation. This is with regard to I believe, the apprehensions that the opposite party had with respect to the code of conduct and the procedure that was followed. So we have full faith in our hospital staff, and in order to hopefully have you also have the same faith, we are offering an independent investigation. It can be any party of your choice, and we will, if you agree for us to conduct it, we will share with you the results, or you can conduct it on your end. We will fully cooperate so that you can be satisfied that we left no stone unturned to save your husband's life. Secondly, coming on to the acknowledgement of the mediation outcome, I believe what my client here was trying to say is, when the process is over, and if you are happy with the mediation outcome and we reach an amicable settlement, in that your family tied over this loss, we have helped you get over this hardship, and you know that you are also happy with the settlement. So this would be the public statement that would be put out. I believe it is clear. But also, I would like to hear from the council on the opposite end that what did you think of the number that we offered? We offered £50,000 before moving on to into the caucus. We are ready to discuss as a number that you are happy with. Could you offer us a counter for that? I believe the mediators can assist us in that regard.
Yes.
If I may just add, sorry, before we move on to further discussion, I just wanted to request our Madam Mediator to brief us on everything that was discussed and everything that we had discussed in the caucus, to just lay it out here as per their expertise.
Yes, thank you. So what was discussed in the caucus, especially from the side of Ray, was that they were willing to settle, they were willing to give an amount of settlement, and what they proposed was 50,000, and they wanted to know what amount you were proposing. And the rest of their proposals have been stated by them directly. And what Sam's side was saying that they wanted a public apology, they wanted a higher education for their children, and they wanted to look into the code of conduct which was taking place, for which Reshan's side has already stated that there'll be an independent investigation as such. Hence, I think the problem here that has to be discussed in brief would be the numbers. Since 50,000 has already been proposed and you are proposing 700,000, what is the middle ground that both the parties would like to achieve?
If I could just
Yes, thank you for pointing. Yes, sorry. I'm just answering Ms. Ray's question that was asked as to numbers, as both the parties here have the numbers as their main concern. I would like you to give out the breakdown for the numbers and why we've come to it on behalf of my client. Initially, my client was asking for £1 million, as already stated, and as both the parties are well aware of. And I think from £1 million coming down to £50,000 was very less. Also, my client's main contention is not just compensation for mental agony. There are certain uh, other factors which cannot be measured, like loss of companionship. The husband could have worked for 15 years more, and the education of both her children in the future, higher education. So considering all that, we've come to this numbers.
Thank you for explaining your perspective here. It's much appreciated. To address this as well, we have put forth some creative offers that we would want you to consider. While I understand that your husband has been a teacher, to facilitate his noble profession, we propose to build a memorial in his memory, called Ashley Memorial Fund, in which essentially crowdfunding can be done, not only from not only by capitalizing on the fact that a riot had taken place on the day that your husband unfortunately passed away, which is essentially something for which the broader society needs to reflect into. I'm sure that a lot of your children's expenses, educational expenses, medical expenses can be covered through crowdfunding. As for your deep regard for your partner, there's also another idea of a free library that we may initiate in the very school that your husband taught in. That is not only a recognition of his noble profession, but also an offering to both your children, where they can get books for free, and also to the others, as a larger part of the of education. Now, the additional offer that we are putting forth as a combination of all of this is a research that we are willing to conduct for the next 2 years, in recognition of the fact that appendix cases need to be looked into from a different angle. I would like to request my counsel to essentially summarize these offers.
Yes, thank you, Mr. Ray. Before we listen to your opinion, I would just like to summarize what all was said here, because I believe my client is fully empathizing with the situation here. And with regard to that, we have offered you a £50,000 settlement in exchange for you withdrawing the court case. However, we are willing to take that number up to around £100,000 if that seems suitable to you. We would like to hear your opinion on the same. Secondly, what was offered is a Ashley Memorial Fund, wherein the hospital would put a token amount of £10,000. So essentially, we are offering £110,000. The hospital will put a £10,000 in the memorial fund, and rest will be crowdfunded. So that memorial fund will fund your children's education, because we do understand that education is very expensive. Your children are very young, and we want to help them have the best careers possible. And therefore, we're willing to set up the fund that will fund their education. Secondly, what was offered was the library in the very school that your husband taught in, to preserve his memory, because to honor the contributions that he made to the education sector. And lastly, what was offered was a research that will be conducted in appendix related cases. So the hospital will donate every 5% of all the profits that it earns in the emergency and accident department over the next 2 years to this research. So I hope we're clear on the terms that we will donate 5% from all the profits that we make in the next 2 years in the emergency department. That will go into the research. At the end of 2 years, we will also publish that research. I believe these will check all your boxes: the money issue, the scholarship issue, and even your husband's legacy is honored. I would really like to hear your opinion regarding the same, because the hospital is doing as much as we can to recognize your husband's legacy and to make sure that none of this happens again.
Yes, I
Thank you,
thank the council and client to have clarified all their proposals. In reply and response to all that, I think what I want to state is that my husband Ashley is no victim here, and I think everything that happened was unfortunate. But I think creating a memorial out of something that is so grave loss to my family would be unjust and unfair. Instead, what I think I would want to counter propose is that if we can, in my husband's name, have mediation committee fund instead that we had mentioned in our general agenda, so that in his name and memory we have more improvement measures with regard to this, and it won't
Sorry
happen
to
to
interrupt.
ensure that it won't happen again.
Sorry to interrupt. I really understand that you got a lot of points to convey, but we actually exceeding the time limit. So please do
Yes.
understand our situation.
So very sorry.
Yes,
Concluded.
yes, parties. So we will take the lead now. Thank you, parties, for your both of the offers. I believe there's a lot of homework to do now because both of parties are now well versed with both the perspective of both the parties, and they know the offers which they can work upon and they discuss upon, considering their long-term, short-term goals. And this would be also an agenda of our next meeting. I believe we have accomplished a lot of agreements unconsciously, which would be formulated in the next meetings. I believe so. I believe we have accomplished a good setting in terms of public apology or public acknowledgement. We have some common grounds, but preferably it should not be quicksand. So to ensure so it's not a quicksand, we do need some time, and so that to ensure that it is some foundation which is solid. So I request the parties to kindly do this homework and we prepare for the next meeting. Now I will request my co-mediator if she has anything else to add to
Yes.
this. But
Adding
from
on
my
to
part, I believe it is very good discussion. Thank you so much, parties, for their participation.
adding on to that, yes, I do believe that there are a lot of emotions at place from the hospital side and from sound side. And yes, we were on different boats miles away, and now we might be a little nearer now. So, what homework I would like to propose the parties is that before you come to the mediation in the next session, hoping that it will happen because there is a long way to go and change cannot happen in one mere session. I would like both the parties to revamp their initiatives, their offers, and also to keep in mind what is it, why have you chose the mediation? I would want to also acknowledge the fact the loss of the loved ones, and I would also acknowledge the fact that how the hospital will be doing good in the future, and how this was a very rare circumstance which took place. So I want both the parties to look into that. Think about that and come up with better creative offers, and yes, in the near future we will reach a middle ground. I request the parties to pivot up, give up their closing statements, and then we can end the session.
Thank you, mediators, to have put everything forward here. I would finally like to conclude by thanking the opposing parties for being present here. And I think although we could not reach a conclusive end, I think we've had a fruitful discussion and reached somewhere. And I think in the future coming negotiations, we can further discuss on the proposals and agendas that we put forward regard to the mediation fund, and also education scholarship that you would be providing my children along with the compensation. I thank you once again, and I hope that we can.
Yes, adding on to my client, what she's just said, it is not very unfortunate since we've already found two grounds that both the parties can mediate upon in the coming proceedings. And yes, I'm really thankful for the mediators to be present here to make my client comfortable. It's very commendable. And I would also like to point out that although this was not something that we could reach a definite conclusion to, we would definitely reach it in the upcoming session. Especially Ray would understand how difficult it can be with these situations, and the council can Ray's council would understand that in these situations how difficult it is to mediate. And that's why I would like to thank both the mediators to even make it easier for the councils in this position to clarify the situation. So thank you so much for your presence here.
I would like to, at the outset, I would like to thank the mediators for despite the difficult circumstances, try their best to make us all feel very comfortable I'd like to naturally thank Ms. Sam for accepting my invitation for this mediation session and playing a good sport. We understand your loss, but at the end of the day, it is your courage that has brought you here, and we are appreciative of that. And I also believe that we've made sufficient progress in this regard. At the end of the session, maybe due to the paucity of time, we were reaching a middle ground, but that could not be settled very well. With regard to the mediation fund that you talked about, that is something which is a point where we feel like there is a very clear point of intersection that we may have. Especially considering that this is a mediation session and everything discussed here will remain confidential. I would like to thank my counsel here as well for advancing our interests and respecting yours. Thank you.
Thank you, Mr. Ray. I would just like to thank the mediators, Tina and Smith, for mediating this session beautifully. And adding on to Ray, I know, Ms. Sam, it took a lot of courage for you to join us at this table today, and I really appreciate that. I hope that you and your family tide over this loss and hopefully find happiness one day. And at the beginning of the session, I said that I hope to see a smile on your faces, and I hope that you would be in a better position than you came in. And just now to hear your counsel say that it is not that unfortunate because we have received some middle ground puts me in a lot of joy that we have gained some ground here, and we would hopefully reach a settlement in the next session. We would certainly be open to listen to the mediation committee fund that you mentioned, and I hope you get the time to mull over all the offers that we have given, because I believe it would ensure your short-term and long-term interests as well. Thank you to everyone, and I hope see you in the next session.
Thank you so much, everyone. So that was indeed a final, I should say. Judges, now we are officially done with the finals. You may give the concluding remarks to the participants. Who's going to first?
I can go.
Yes, sir.
Okay, wonderful. Can everyone hear me? Okay.
Yes, sir. Perfect.
I would like, first of all, to congratulate you all. You have demonstrated lots of passion, understanding of the mediation values, the process. You were all active, engaging. I'm proud of all of you, and to my eyes, you are all winners. Thank you very much for what you have just demonstrated. Despite the grades and the results, I just have like few let's just say notes and highlights for your future that you might find it beneficial. In your opening statement as the mediators, I hope in the future. But just before I tell you any of this, I know that this is not fair to deal with a highly complex case like this in 50 minutes or an hour. It's absolutely, I know that it would be very difficult for you to try to push in all of the skills and the tools in this amount of time. So I understand, but for the real life, there's few points I hope you would find it useful. So in your opening statement as a mediator, people, most of the time, they have picked you till they know you, and others, especially like in the mandatory mediation schemes and so on, they haven't really knows you. So it's good for you to tell them a little bit about your competences, about a little bit of your experience as a mediator, so they would feel that they are in a good hand. So that is first. The second thing is try to mention one or two things as your personal, when appropriate, to try to bond, to build rapport with the party. So this is for the opening statement. Also, you have done well assuring the party's confidentiality, and also I don't know the names, so the IMC 2335 mediator. You've also done well to assure them confidentiality one more time in the caucus. But for the future, please consider that you should also tell them what is the ground of such confidentiality. Is there a law? Is there an agreement? And also try to mention if there is exceptions of such confidentiality, because you've mentioned several that it's absolute. Is it really absolute? Be quite cautious of what you are promising the parties before you do any promise. A little bit for the parties. You've done your roles very professional. It was very clear that it would have been very similar if it was in real life. I appreciate all of your efforts. But I also would like to just identify something, especially for Ray's team, which is IMC 2325. You've been highly dominating, confident. You would have made an excellent direct communication process, a direct negotiation process. You've been dominating everything. You've been doing the offers, the counter offers, which was excellent. But my question to you is, how did you actually benefited from the mediation? How did you actually get a use of the mediators there? This is something for the future. Please stay strong, stay confident, stay powerful in your cases. But if you are in mediation, use it. Use the mediators, and this is something for Ray. Another thing, which is I wanted to say yes to the mediators. You've done well managing the process overall, but when it comes to the negotiation or the communication phase of the process, and again, I know it's unfair to deal with all of these details in just very brief time, but I have like a small advice to you. Do not let the parties through the first offer in the joint session without meeting with them first, because this is very risky. If the expectation of one of the parties is 1 million British pound, and all of the sudden, like they have thrown there 50,000 in a compensation, this could be an insulting one. This could be frustrating the whole thing, and people would walk away. So it is better to get them in caucus, and you would call the call and say, let's go for caucus before talking numbers or before talking offers, and get to tell them, okay, so why 50,000? Why do you think they will accept it? Is this would throw them away? Would this keep them in the room? How can we keep them engaged? And so on. And again, also when you have met Sam in caucus, which is good that you get their offers in caucus, and they did throw a lot of offers, but I was expecting from you that you would challenge such offer, get some rationale, some logic behind it, before just take it in there. Okay, so this is your offer, good summarizing, and you go to the other one. Just put it in test first, and get as much as logic and evidence to it before leaving these parts. Overall, and also for the IMC 2335, which is Sam, you've done well using your lawyer in the room. You have referred to your lawyer several times, which is if it's a legal talk or anything, you just refer it to the lawyer and the lawyer go in. And the lawyer also done well not dominating the talk and also giving you a space. So you've also done very well. Once again, thank you very much for demonstrating your passion, your understanding. I'm proud of you, and you really deserve to be in the finals. It's a pleasure to get to know all of you.
Thank you so much, sir.
Yeah, organizers, can I do the feedback?
Yes, sir, you may.
Yeah, yeah, awesome. Both the teams have done very well. I couldn't imagine that you people are just students I could very well observe that you all are real professionals, professional lawyers, mediators, and obviously the role of the parties also is excellent. No doubt on it. When it comes to the feedback, what I wanted to personally put upon here is that the communication skill, what I could see from the entire mediators team, the mediators and the co-mediators, was awesome. The only thing what it has to be developed is that you need not too much get involved from the inputs given from the parties. You can also very well frame up the terms, the settlement terms. You can also come with proposals. It's all about whether it is going to be evaluative or facilitative. In that way, obviously, being part of the Indian legal system, the Mediation Act, which is on the downline of the common law system, we can always try to have a evaluative type also. When though it's internationally, it is not so acceptable, you can also try it. This is one interesting point what I wanted to share with the mediators. When it comes to the one defect what I can see in the mediator's role is that the mediator should not cut short the proposals in the private caucuses given by the parties or the parties' counsel. I could see one of the mediator happened to just try to cut short certain proposals not to be taken in the private caucus. That we had to try to avoid. Otherwise, perfect. Hats off. Both the mediators have done very well. Regarding the client and the counsel, the coordination was really good. Even though one of the team, the counsel and the client happened to be in different location, the coordinations were really good, and the narrations given by the counsels on behalf of the client also is acceptable. It is the only thing is that if it would have been in a physical mode, as rightly pointed out by the other judge, the time given is quite short for the parties to put forward. But anyway, one thing you have to keep in mind, medical negligence or all these aspects, when it comes to Indian jurisdiction, we do have a challenge on to what extent we can mediate these. The aspect of the applicability of the Mediation Act 2023, I could see evident in the presentations by the client as well as the counsel. Hats off and best wishes for your career. Thank you.
Thank you, sir. Thank you so much for your words. And next, we have Pradeep Kama, sir.
Yeah, well, I don't want to keep you too long because everybody's waiting for the result. But of course, I align myself with everything that's been said by the other judges. It's quite difficult to really display all your mediation skills and client counsel skills on this sort of format. And on a simple basis, for instance, body language, use of body language is almost impossible online. And just to give you an example where body language has been very helpful, or I've come across it in a mediation that I was dealing with as a barrister, I noticed we had a very skilled mediator. So on the first caucus, he sat at the end of the table and he let me and my client sit together so he could hear the view as expressed through the lawyer. But I noticed when he came back for the second caucus, he sat between me and my client. So now he got in between us and he wanted to know what the client's real point was. So that's very difficult online. Secondly, in every mediation that I've been in, I haven't been in as many as the other judges, but I've been in many. There's much more use of the private caucus, firstly. And secondly, as a barrister dealing with mediations, I was very loath to let my clients really conduct much of the open sessions unless there was some real deadlock. I can think of one case in which eventually the mediator said to the lay client, "You want to say something, you say." He said, "Yeah." He said, if we don't get £1 million, we're out of business. So if there's any deal below that, there's no point. And at least that sort of set the parameters so people were, realized what was involved. So I'll just make those 2 points. But I agree with everybody else, Dr. El-Ganahi and Mr. Idvarichan, that everybody did extremely well given those parameters. The only added value I would give to what has been said so far is don't let mediation be your only skill. This was a legally based mediation. It involved clinical negligence. And if you're going to have the confidence of the parties and you're going to make headway to work out the motivation behind the parties and what's a realistic settlement, which you can do some reality testing on, you really do need to know how the law works and how a clinical negligence claim works. And for instance, in this case, in a clinical negligence claim in this case, you had these two issues. One was, should the nurse have spotted something and been more alert, which is really possibly the potential weakness. The process weakness, that it took 8 hours, not 4 hours, that's always going to be more difficult to argue in a court. And if you know about the law on these matters, you know that. And as was said by Dr. El-Nagahi, you have to give reasons for the value you put in your claim. And from a clinical negligence claim, you'd work out what's the max, if you're the claimant, what's the maximum value, what's my percentage chances of winning, and you would compare those two to come to a figure. And so in order to know what's your maximum value, you'd say, well, there's the pain suffering. You'd look at all the elements of damage, the pain suffering, the loss of immunity, the fatal accidents award, not getting loss of dependency. This person might be contributing to the family. Would they have paid for the? You'd set that out all in a schedule, and then and you'd be showing that to the mediator, and the other side would then have a reasoned basis. But if you start off with £700,000 and £50,000, it's very, very difficult to get close. And that's really why you'd probably use the caucus much more, because you'd be going back, mediator be going backwards and forwards, saying, well, they're saying this on this figure, that on that figure. Okay, and then you say, well, we'll park the figures for a minute. Let's look at chances of success here. And then you can add in all these extras, these which help with the deal, like creating a library, doing something in honor of the deceased. So the takeaway from that is that if you're doing a mediation in a particular field, it really is very important that you know all about that area of law. If you do it in another field, I had one involving a housing association, and we could sort of sort the case out by buying somebody else's land. That got rid of one of the issues. The mediator knew all about how housing associations are financed, where the money could come from. So the client had complete confidence in the mediator that they knew that they were talking about. Well, I said everybody's waiting for the result, and I've gone on too long. So that's all I'm going to say. But thank you very much for your efforts. You all did, as I say, very well, and it was very close. And perhaps I'll just add this. I think if you do approach it from the point of view of how would a court look at this, right? So what's the potential outcome? Work out the value, work out the chance of success. You could probably have settled the case pretty quickly, actually. A case of this sort. Yes, there we are.
Thank you so much. So participants, how you all feel? You're all ready for the results, I guess. But we will take a 20 minutes break and we will announce the result during the valedictory function. So I could see the smiles because all your hard works, this days of discussions, all be coming to an end. So participants, you may leave the meeting. And judges, you can share a word or any doubts or clarification you needed.
Can I ask a question, if that's allowed, to the judges?
Can you sum up in a few minutes?
It may not necessarily
yeah.
be answered, but yeah. What's the question?
Yes, sir. Yeah, I wanted to gain some perspective as to the feedback that was given. So you mentioned that we need to be thorough with the law aspect of mediation as well, and we should just not do mediation for the sake of it. So I want to know that we've always been advised that in a mediation session, the nitty-gritties of law have to be kept to the minimum. So although we did study upon medical negligence in all its aspects, we deliberately kept it to the minimum so that as to not to confuse the other party or intimidate it
Yeah.
with our legal knowledge. So how do we deal with that? How do we
Well, there's
strike
a
a
good
balance?
question. That's a very good question. I said, Matt, you may not get an answer, but you have to work in the real world. You know, in the context of a competition, fair enough. They don't want a lot of law being bandied about. But in the real world, in a clinical negligence case where somebody has died, you'd have some pretty senior barristers on each side representing the parties, and they'd know precisely what the law is, and they'd both have an idea what their best case was. And in order to then understand where they're coming from, where they see the strengths and weaknesses, and therefore, as I say, to sometimes do a reality check, say, well, how do you support that figure? Because, you know, the other side will want to know when we come to do this, how you get to the figure. You do actually need to know the background. So it's right enough. You don't use the mediation to argue the law across the mediation, you know. You don't say, well, there's this case and that decided this, that's what we're relying on, and then you don't deal with that. But you do need to know the greater background. And I guess, I mean, I've never mediated anything outside a legal case, yeah. But I guess if you're mediating in some political dispute, you need to know the background of the politics and all the history of the politics. You can't just step into it and say, well, I've got mediation skills which are divorced from the subject matter and not know anything about the subject matter. That's, I mean, Dr. El Nagahi, you're more of an internationalist. So is that your view, or maybe not?
This is an excellent answer. And also address it from a different dimension. Thank you for your excellent question. Let me tell you that I spent around 6 years doing my PhD trying to answer one question, and the question was, can mediation deliver justice? That was the question that I was trying to answer. And the reason why I picked this question is because I believe if you are in a conflict, it doesn't matter which method you will try to use to resolve it, whether it's litigation, arbitration, negotiation, mediation, whatever the method. It will not be truly resolved unless if the parties got a sense of fairness of the result. If you got that both parties have a sense of fairness, you know what, this is fair, we can accept this, then you can truly have satisfied party, and you can truly have people with peace of mind. With this being said, I would encourage you. I've made like a summary of my PhD, and I think it's 26 pages in a paper called "Can Mediation Deliver Justice?" If you Google my name, Sharif Al-Nagahi, and then put "Can Mediation Deliver Justice?" I think you would find it online. I'll make sure that it's available. It's free. You can download it and read it. With this being said, in my opinion, if you are trying to search for what is fair, what is just, you need to bring back the balance between the two parties that have been disturbed because of the conflict. To bring back the balance, you need to resort to some values. These values can be the legal, can be cultural, can be emotional, can be logical. It's up to the parties to decide what matters the most. In litigation and arbitration, people usually only refer to the legal values of the case. But in mediation, legal values of the case is important, and you can resort to it, and please do. But also, it opened the floor for the other values to consider. And then it's up to the parties to say, you know what, this value is what matters to me, and this is what will make me feel fair, satisfied, just outcome. I know it's a little bit philosophical, but I hope that if you are really interested, take a look at this paper, read it, and I hope that you would find some good food for thoughts into it.
Thank you so much to both the judges. I will definitely look forward to reading that paper.
Thank you, sir.
Thank you, judges.
Participants, please leave the meeting. Judges can remain in the meeting. Thank you so much. Sir, already Sharif sir and Inpajan sir already sent the score sheet. So prior to sending the score sheet, you want to discuss. If that's so, we can arrange a breakout room because this link is already in live in the YouTube.
Just before doing the breakout room, I already sent my score sheets, and signed it and everything to the email. I've received the blank, so this is to confirm this. Are we still needed to stay after the 20 minutes?
So we already received your score sheet. It's confirmed with the team. I already confirmed with the team. Now we'll take a 20 minutes break. Okay. After that, we will start the valedictory function. Sound clear to you?
Okay. So my question is, am I still needed to stay in?
No. I'm just asking whether the judges need a discussion as such, because this time we can share your words with each other about the whole round if you want to. That's it. So Philip sir, what you are trying to?
Yeah, I'm all right without a discussion. I think we'll all have our independent. I think if one of the judges anyway has handed in their sheet, it's rather dangerous to have a discussion because it may suggest that others being influenced by what has already been done. So I'm happy not to have a discussion, and but I haven't sent in my sheet yet, so I've got to do that.
That sounds amazing. That's it. So
my mathematics is a bit slow.
Okay.
Before I leave, Philip, it has been a pleasure to collaborate and work with you. Truly,
yeah.
It's truly a pleasure. I've tried to look to you on LinkedIn, but I couldn't. So
I don't do social media.
I had a feeling. But I hope that I will be in touch.
Yeah, well, that's lovely.
Yeah. Sorry, sir. Sorry for the sound.
I tell you what, have I got your email address on this?
So I will put it in the chat box.
Yes, please.
Put it in the chat box, and I'll email you, because in fact I just retired on the 9th of November, so you can't even get at me through the judicial channels anymore. But I'll send you an email. It's been great working with you, and
sorry, sir, for the inconvenience caused.
Okay,
I meant to say
I better get on with my. Huh?
Sorry for the inconvenience caused. I meant to say the email which you have to send the score sheet. And Sharif sir, you can share your email.
Okay. Right, I'll send the score sheet. Right, very good idea.
Perfect, sir. Perfect.
So, do I need to log out before I do that, or can I stay logged in?
You can log in. It's fine.
Yeah. Okay.
So we'll have the valedictory session in the same link.
I'm looking at the administrator screen, that's why. Yeah. So I can't go into chat. All right, I'm out.
So do you want the access to chats?
Yeah. Well, listen, first I'll do the my score sheet, otherwise that'll hold everything.
Screen, that's right. Okay, all right, that's fine. So you can log out from the meeting, you can send the score sheet, and you can join.
I'll do the score sheet. I'll do the score sheet at first, yeah.
Right. Thank you, sir. Thank you so much.
Six, 10, 14, 17. Six, 2, 3, 4, 5, 6, 24, 29, 29.
So, are you done with the math part?
I'm just typing.
It's fine. I just confirm. Just let me know once you done sending the mail, okay?
Yeah.
Perfect. Thank you, sir.
And who do I email it to?
So, I will just a minute.
Um, Right, I've just emailed my score sheet to the address that I received the score sheet from. I hope it's going.
Let me check with my team. Just a minute.
Something's in the outbox here. We're having trouble opening this item. Restart Outlook.
So you have sent the score sheet to dataimc@gmail.com, right?
Yeah, you've got. Have you got it now?
Yeah, I have got it right now.
Oh, excellent. Very good.
So perfect. Very good. And sorry for the inconvenience for the technical glitch that happened from our side.
Not at all.
Thank
It's
you
a
so much,
miracle that we
sir.
can do this at all.
10 minutes, 10 minutes.
All right. So,
So-
when will I see you next?
Can you join within 10 minutes? Is it possible?
10
You
minutes.
can take a
That's
break.
fine, that's
Yeah.
fine. 10
So
minutes.
thank you
Okay.
so much, sir. We will see you soon. Bye-bye.
Yep.
Hello, everyone. Philip, sir, can you check your WhatsApp status, please? So, can you check your WhatsApp message?
Good evening, sir. Are we ready to go? Good evening, ma'am.
Good evening.
Good evening. Shall we start then?
Yeah.
Perfect. Thank you. Mediation is conflict's way of looking at itself. Even the great leader Abraham Lincoln once said, "Discourage litigation, persuade your neighbors to compromise whenever you can." Good evening, ladies and gentlemen. Firstly, I take this opportunity to welcome you all to the valedictory ceremony of the third edition of the International Mediation Contest conducted by Lex Erudites in collaboration with Newcastle University. The sheer magnificence of the event has scaled even further with the presence of our renowned guests and vigorous competitions that took place during the course of the last 3 days. Mediation should never be a last resort, while such dialogue and deliberation should be encouraged to initiate and explore the widest horizons of solution. On that note, I would like to invite His Honor Judge Philip Kramer to address the gathering. Philip Kramer is the judge in charge of the business and property courts in Newcastle. He also sits in Leeds and at the Rolls Building. He is authorized to sit as a judge of the High Court in both the Chancery and Queen's Bench divisions, including the Circuit Commercial and Technology and Construction Courts and Administrative Courts as well. His Honor, Judge Kramer is a graduate of the University of Newcastle upon time and practiced in Newcastle as a barrister and arbitrator. He was appointed as a district judge in 2013 and specialist civil circuit judge in 2017. Sir, it's my proud privilege to welcome you onto the dais, and I humbly request you to address the gathering.
Well, thank you very much. Things have moved on slightly since that little bio was prepared, since I retired on the 9th of November, although as luck has it, not everybody's available to get their last judgment on the 9th of November, so I actually downed tools, moved my wig on the 14th of November. Well, this is my first opportunity to say how grateful I am to have been asked to co-judge this mediation competition, which was very unusual, something completely new to me, a competition of this sort, and I can just see how valuable it is. And I'd also like to thank the two distinguished judges who judged alongside me, Dr. El Nagahi, who I see online, and our other judge, who, due to a typhoon in his part of the world, I couldn't actually see, but I'd like to thank both of them. I was introduced to this competition by Professor Brian Clark, who seems to be of Newcastle University, who seems to be something of the midwife of this competition. Today I'm dealt with the judging from the library at Newcastle University, where I sat as a student almost 50 years ago. So it brings home some very pleasant memories. it's a competition which clearly makes a very valuable contribution to the development of mediation as a dispute resolution mechanism. And just to put this in context, I looked at some figures from NHS Resolution. This is the arm's length organization of the National Health Service, who deal with their clinical negligence and public liability claims in relation to staff, but just dealing with clinical negligence. They receive over 10,000 claims a year. Of those, 30% end in litigation. Of those, 1% go to trial. Well, that gives you some indication how effective they are at resolving issues. And indeed, in over 50%, there is no financial payment at all, right? And they have increased their mediation to the point where for every 7 cases they deal with, 6 are mediated and are dealt with in mediation, and 1 goes on to trial. So that puts that in context. And there's also another interesting figure I saw, although possibly self-serving. The ADR group, which is an accrediting mediation group in England, they produced a figure that 80% of mediations settle the case. So that's effective in 80% of the cases. And of course, there's going to be cases where the mediation doesn't settle, but the parties work out what the issues were at the mediation and then settle shortly afterwards. The other aspect, I think, important aspect of this competition is how it has brought people from right across the world together through the medium of Zoom. We have Dr. Eldegahi in Cairo. I'm in a snowbound Newcastle, and I know my other judge was in a typhoon hit part of the world. So quite apart from bringing them together, it enables academic institutions to make connections, and that's very important in a global world, and certainly in the common law jurisdictions. And it surprised me how rarely Commonwealth authorities are referred to in certainly in the courts in which I practiced. I used to have volumes of the British and Commonwealth Digest. Used to go to the library for that. And if you were really stuck on a problem and you couldn't find some authority, off I went to the British and Commonwealth Digest, and you got some very interesting decisions from around the world, which were persuasive authority, and at least they marshaled the arguments. So I think it is valuable that we come closer together, certainly in the common law world. I'm not excluding the non-common law world from that, but they obviously have experience of the common law. And as regards mediation, for those of you who are interested, just on the 29th of November, which is not so long ago, the Court of Appeal in this country, in the case of Churchill and Merthyr Tydfil Council, ruled that a court has power to order mediation, whether or not the parties want it. Usually it'll be one party does, as was the case in Merthyr. But they can order it, although that was the helpful bit. The unhelpful bit was they said they weren't going to explain the principles upon which you would order it, although if you look at the judgment, they identify principles which the Bar Council suggested would be relevant as to deciding whether somebody was unreasonable in not mediating. And they said those principles may well be valuable in deciding whether to order mediation. So that's the first unhelpful bit. The second unhelpful bit was that, well, actually it's second and a half unhelpful bit was that it wasn't a true mediation case, Merthyr, because what Merthyr Tydfil wanted was the claimant, Mr. Churchill, to go through their complaints procedure before he litigated. Secondly, they decided that even though they could order mediation, they wouldn't. So we don't know, as a precedent, what it was that would have caused them to order mediation in that case. But there it is. And I can see in future parties will be saying, look, this case ought to be mediated, although usually it's the judge who's suggesting it. Certainly, we have a system of case management in which the court takes the lead in managing a case, and judges will often say, listen, this really needs to be mediated. Or we have a system of early neutral evaluation where you can put your case before another judge who's not going to deal with the case, and they can just give you an idea of what's going to happen. And that's often quite a useful tool for the parties' lawyers then to say to their clients, well, that's the case, that's the way the case is likely to play out. So you may want to have some negotiation about that, either direct or through mediation. So that's all I have to say about mediation. And as ever, I'd like to thank my fellow judges and those who organised this, which must have been very difficult. So it's a very complex thing to organise everybody together. I'd like to thank the organisers as well.
Thank you very much, sir. Indeed, very resourceful words as well. I think with respect to the fact that the effectiveness can very well be a judge for knowing how we can rate mediation, but at the same time, cultural differences in different society will help us to mold as to how exactly mediation works differently in different societies, like be it India for that aspect, be it UK for that aspect. The way in which mediation works is completely different. So I think to bring some level of uniform ground is something that we need to work on by encouraging more of mediation practices in these kind of countries. So thank you very much, sir. Next up, I take this opportunity to invite another eminent personality amongst us who we're very fortunate to have as a judge, Honorable Dr. Sharif El Negahi, mediator of the Global Mediation Panel of the Office of the Ombudsman for UN Funds and Programs. Sir, I humbly request you to address the gathering.
Thank you very much for having me. I think this is the third year I'm participating in this, and it's quite a pleasure and honor to support all of your efforts into encouraging the young student to embrace mediation and consider it as one of the potential career and potential paths in their law fields. I vividly remember that in 2008, when I was starting my LLM studies at Pepperdine University, and there was a mandatory course in mediation, and I was like, oh, what is mediation and why people are studying this? And it led me to do a lot of practical experience at LA Superior Court and acted as a mediator at more than 220 hours of mediation and see the cases. And I was really into litigation and arbitration. And then I've seen the magic and the powers of mediation, which has led me later on to start my PhD under the supervision of Professor Brian Clark for 6 years, trying to answer one question: can mediation deliver justice? It was fascinating. But I also vividly remember that all of my friends and family was telling me that I'm crazy because I've started to dedicate my time, my efforts into a subject that does not have any clear career path. Now I would love to say that the international community have recognized the power of mediation. Now we have the Singapore Mediation Convention, and countries keep signing and rectifying such convention every day, giving an international recognition for the commercial and international commercial mediation, and which is quite significant. I've also been fortunate to be offered lots of opportunities in the mediation field. I've seen the power of what's so-called community company mediation, where major companies are in conflict with large number of communities, and how mediation actually interfere and help this, which is definitely support the economy of different countries. I've also been humbled and fortunate to see mediation works into the UN arena. The UN also, which is different with different mechanism and different agencies, have recognized the power of mediation to resolve all of the workplace disputes, and it have been encouraging their staff to resort to mediation when dealing with the workplace disputes. And it have been the satisfactory level, the settlement level is very high and very appreciated. I've also been seeing lots of governments, and I was quite fortunate to deal with such governments, to give them consultation, especially the Saudi Arabia Kingdom, have been highly invested into encouraging mediation and put it at one of their pillars of the justice system across the kingdom, of how mediation would work and benefit the citizen and also the international investors. It's quite joyful to see how mediation is keep holding its ground and prove its benefit into different areas into the world. And I would thank the organizers for shed some light to this benefit and encouraging their students and international students to give it a go and to consider it early on in their career. So thank you for the organizer for inviting me. And also it's quite a pleasure to meet distinguished judges, Philip Kramer. I hope I stay in touch. And also special thanks to Professor Brian Clark for definitely encouraging me to stay active in this competition. Thank you all very much. I should not talk anymore. I know that the anticipation is high. Everyone wants to know the results. I want to know the results. So back to you.
Thank you very much, sir. Thank you very much, sir. We indeed appreciate your efforts of being there with us as a judge, and we couldn't be more honored by your presence, sir. Thank you very much. Next up, I think it would be unfair if I don't use this opportunity to thank Inba Vijayan, sir, the third judge at finals, for keeping some time away from his hectic schedule to be with us and also facilitated the ease of our conduct for today. I think let's just say that the typhoon was an act of God, and it is a reasonable defense for him. And we wish him all the very best in all his future endeavors. And we are very grateful for sir's presence. Thank you very much, sir. Now, I would like to call upon Ms. Samantha Ryan, Lecturer of Law, BCL, University College Cork, LLM, University College Cork, MPhil, King's College London. In 1999, she was awarded a traveling studentship in law by the National University of Ireland. As a representative of Lex Erudites, I take this opportunity to thank her for the support they have extended and request her to kindly address the gathering. Ma'am, please.
Hello, good evening from Newcastle. Good evening, esteemed judges, other guests, competitors, organisers and students. Newcastle Law School is really honoured to have been involved this year as co-host, but of course with Professor Brian Clark, we've had connections with this competition for 3 years now. And I do want to thank in particular our law students who have helped in many ways with this event over the last 3 days, also competed, some of them. So I'm hoping for good news in a moment when we find out how all of the competitions have gone. And I particularly want to thank Judge Philip Kramer for judging today. Great to see an alumnus of the university being involved too. I won't keep you too long, but I do just want to say a brief word to all the competitors. I want to congratulate and commend you all for taking the time to be involved in something like this. I truly commend you. It is not an easy thing to do, to put yourself out there and to try and develop and hone these particular skills. And I do want to reiterate something that Professor Brian Clark had said. These are skills that will be useful to you no matter what career you end up pursuing. We know that mediation is becoming more and more present in multiple jurisdictions and in multiple areas of law, but the skills that you will develop through doing these kinds of competitions and through learning more about mediation will stand you in good stead in multiple arenas. As a mother, I know I try and use many of these skills dealing with my children on a daily basis. So the ability to listen actively, to communicate effectively, to manage emotions, to negotiate and to try and resolve conflict are key transferable skills for whatever you do want to do. And just finally, I would like to express my thanks to Lex Erudites, who have been phenomenal to work with, and to just say that Newcastle Law School looks forward to continuing and strengthening our collaboration and partnership. Thank you all very much.
Thank you very much, ma'am. And I think the feeling is mutual, and we're also looking forward to collaborations with Newcastle University in the coming years. Thank you very much, ma'am. I think it's about time that we move on to the much awaited moment, and all the participants are eagerly waiting towards the declaration of the results. And to do the honors, I request our very honorable judge, His Honor Judge Philip Kramer, sir, to please announce the results. Sir, please.
I don't think I've received them yet, actually. So the tension mounts because I've received a blank sheet, but not the final sheet.
Sir, could you please check your WhatsApp? I think the results.
WhatsApp. It's on WhatsApp.
Yes, sir. Yes, it's been sent. Please. Thank you.
Got it?
All right, sir.
So so the results are as follows. The best team was team 2325 from the Rajiv Gandhi Newcastle University of Law, Punjab in India. The runners-up, second best team were 2335, Christ deemed to be University, Pune, India. And the best mediator was in team 2316, Ronit Rampuraya from National Law Institute University, Bhopal in India. So those are the results. Well, those are the results, but congratulations to the winners, but congratulations to those who didn't win as well, because this was a win by a whisker, and you're both winners being in the final. And you're all to be commended for very fine performances and making it so difficult for the judges. That's what judges often find. People make it very difficult for the judges, and you certainly did.
Thank you very much, sir. I mean, indeed, it is an opportunity where we should appreciate all the participants that have been involved in this edition of the International Mediation Contest. I think over the course of the last 3 days, the competition has been very vigorous. The competition has been absolute, and everybody has given their best effort. So I take this opportunity on behalf of the organizing committee to thank each and every participant of this competition. Thank you very much, sir. Last but not the least, I call upon the heart and soul of the contest, our beloved convener and the backbone of Lex Erudites, Shivadat Madhumenan, to propose a vote of thanks. Shivadat, please.
Well, thank you, Karthik. We're actually excited to hear that we have 3 billion winners from this year's mediation competition. Now, it is indeed a proud moment for Lex Erudites as well as Newcastle University as we bring down the curtains of the 3rd edition of our International Mediation Competition 2023. Now, before moving on to my duty of proposing the vote of thanks, what I would like to say is that I've been associated with this competition for the past 3 years from its first edition, as Sharif sir knows and as Brian sir knows. And I was indeed fortunate to have to interact with multiple judges, participants, and academicians from all over the world. Now, Lex Erudites, way back in 2021, after a conversation with Professor Clark, the main objective of this competition was that I'm coming from an ordinary government law college based in the southern state of Kerala, India. Now, what we particularly see is that mediation is just confined to a part of a syllabus, probably in their last semester or so, wherein students get to do a role play. And in fact, what I believe is that the power of mediation is not known to the students. In fact, it is not because they're not known, it's because that they don't get to experience or learn what mediation is. So with this competition, our main objective was that in all law schools, basically in India, we have a very good mooting culture. But what lacks is an ADR platform. Well, although many law schools have what I would say in common, like moot court societies, we won't see ADR society. So, in fact, we found this as a platform where we believe that we could provide them with a learning experience and also to provide them a platform where they can accustom with this practice of mediation. And what I would say is that I feel we have been successful in implementing this idea and project because, as we know, to the number of registrations that we have received this year, I would say 70% of the registrations were actually from India because as you know, as I mentioned earlier, we didn't have this ADR culture. Now what I could see is that my college itself is now registering with a multiple number of teams to this competition. It's heartening to see that because what we intend to achieve through this competition is probably achieved because we are successful in ensuring that the students get to know the power of mediation, and we are grateful to that. Now, as I don't want to, go on make this session extended. So first and foremost, let me thank the distinguished adjudicators for the day. His Honor Philip Kramer, sir, Honorable Dr. Sharif El Nagahi, sir, and Mr. Imba Vijayan Veeraragavan, sir. Because what I believe is that with your valuable feedback, participants get to learn and also to improve their mediation skills, and probably, those who are not going to graduate, they'll be back here next time, and let's see how they perform. Probably this competition and this feedback that you have provided is going to be an asset for them. So thank you once again on behalf of Lex Erudites as well as Newcastle University. I would like to extend our deepest gratitude to all three members of the adjudicating panel. Now moving on, Samantha Rai, ma'am, and I think Dr. Jonathan Galloway. Thank you for making this project a reality through Professor Brian Clark. Because even though we had planned to organize this in person, but due to various other logistical issues, we had to conduct this competition in an online format because we didn't want to miss an edition because the learning process should continue. And thank you for making this project a reality with your valuable collaboration. I certainly believe that we were able to achieve what we wanted to. So thank you once again, and we look forward to collaborating with your prestigious institution in the near future. Thank you, ma'am, and thank you, sir. Now, specific thanks to the patron of the third edition as well as first, second edition, Professor Dr. Brian Clark. Because what I would say is that Brian Clark, sir, was sitting there in UK and shedding light to a small state here in Kerala, where our team is based in, giving us guidance in every step from registrations and creating or drafting scenarios to ensure that we connect with judges, experts, scholars, and also the workshop that he conducts. Well, I would say he has a stardom within the students who actually attends the workshop. So thank you, Brian, sir, in his absence for your constant guidance and support. And in fact, we are honored to have received this support from him, and we look forward to also. Now, this competition, without the active involvement of volunteers, it is impossible for us to bring or pull up a competition of this scale. As per this year's statistics, what I would say is that we had 40 teams from all over the world. 40 teams with 3 members each, that is 120 members. And with 10 virtual mediation rooms and with 25 plus judges, we had to organize this entire competition in 4 different rounds. So the logistical aspect of this competition, as we consider, is humongous. We'll have to send out the links and also to ensure that they've joined, to ensure the scoring goes smooth. Particularly, let me thank the tech team from Newcastle University, comprising of 16 members, who have meticulous and have also cooperated from the day one in ensuring that all these steps from training session to the last and final part, ensuring that scores are in. Thank you so much to all the members for your dedication towards this competition. And I feel without their dedication, it was impossible to pull up a competition of this scale. So thanks to all 16 members from the tech team. Now, my own team from Lex Erudites. So team Lex Erudites is, we have members from different parts of India. So we mostly work remotely, and quite often we do join in some places. So to all my members from day one, setting up this whole platform, bringing in registration, ensuring that the word about this competition reaches in every parts of the world. Thank you all, including the co-founders of Lex Erudites, Arun Vaidyanathan and Lakshmi Vandana, and the team comprising of Amrita, Atmaja Menon, Ellen, Karthik, and all other members, because as I said earlier, all three editions, their constant inputs were there, due to which we are able to pull up a competition again this year. And we look forward to hosting our editions in the upcoming years also. And probably in an in-person format, because I guess, the experience of having this competition in in-person format is something which is great, because they get to interact and network with experts like Sharif sir and Philip sir. And we look forward to hosting this competition in an in-person format in next year. And to our mentors, Advocate Akhil George, who had actually drafted the scenarios for films 1 and films 2, and also to Advocate Gajendra Singh Rajkaroy for their unwavering support. So initially, Lex Erudites was actually a student initiative. Now with various members who have actually graduated, we have lawyers, students, and academicians. Now it's a mix of meritorious community of legal professionals. So thank you to each one of you, and we wish everyone the best of luck, to all the team members, participants, because without participants, this competition would not have become a grand success. So thank you to each one of the participants, and we look forward to your participation in the upcoming edition also. And to Karthik and Vismaya, thank you for being an exceptional host for the finals as well as the valedictory session. Thank you so much. Thank you.
Thank you, Shivdat. I think this is what it eventually comes down to. A group of students coming around with the vision of promoting mediation culture in a country. And with every new team or every new student that takes up being a participant in such mediation contests, we walk one step closer to our dream. And I think, as the saying goes, dream big, dream high, shoot for the moon. Even if you miss, you will reach among the stars. And with the dream, Lex Erudites moves forward. And we hope that in the coming future sessions as well, we're able to collaborate with universities as prestigious as Newcastle University and make our dream a reality in person as well. Thank you very much to all the renowned guests and judges who are a part of today's session, and all the participants for making this event extremely grand. I wish you all the very best and wish you all the love and joy this year. Thank you.
Thank you, everyone. Thank you.